Hello and welcome. This is Kathleen Lovito, and I'll be your host for today's webinar on estate planning basics. Our presenter today is Sarah Bumgardner, Relationship Manager with AAFMAA Wealth Management and Trust. Before we begin, here's a quick background on the company. This webinar series is brought to you by AAFMAA Wealth Management and Trust. Our mission is to be the premier provider of financial planning, investment management, and trust services to the American Armed Forces community. AAFMAA Wealth Management and Trust is a wholly owned subsidiary of AAFMAA. AAFMAA has proudly served America's armed forces since 1879. AAFMAA is a nonprofit, tax-exempt 501c23 member-owned mutual aid association, offering life insurance to all branches of the U.S. Armed Forces and their families. And just a few disclaimers. This presentation is educational, is for general information only, and is not specific investment, legal, or tax advice for any of you individually. Do not rely on this presentation alone to guide your investment management decisions. Since each situation is unique, your needs for financial services will differ. If for individual advice, please contact us directly. We produce this webinar series in-house with our own professional staff as a service to our members to help them better understand the resources available to them. We have highlighted here two distinct characteristics that separate AAFMAA Wealth Management and Trust from other service providers. One, our fiduciary standard, which requires us to always act in our clients' best interests. And two, we exclusively serve the U.S. Armed Forces community. So without further ado, I'll turn it over to Sarah to begin the presentation.
Thank you everyone for joining us. I'm Sarah Bumgardner, and today's webinar is Estate Planning 101 Military Edition. As you can see from our agenda, we will be going over the basics of building an estate plan, what's included, why it's important, and special considerations for military families. Estate plans can seem overwhelming to start, but they're essential in the event that anything happened to you. So why do you need an estate plan? An estate plan is important to protect not only yourself, but your loved ones during your lifetime and also after death. My goal is to get everyone thinking and asking questions so that you can confidently sleep at night knowing you and your family are protected. There are 4 main points I'm going to review today that can help facilitate this and will ultimately safeguard the financial security of you and your loved ones. Ongoing management of finances, healthcare, control and protection of assets, minimize potential estate tax. We will look at ongoing management of your finances and assets first. How many assets you have versus how much debt you leave behind can have a large impact on those inheriting your assets. Who is going to manage the assets? Do you trust them? Next is healthcare. Is there enough money to cover long-term care? Do people know what your wishes are should you be incapacitated? All of this is covered in your estate plan. We will then look at our third point, control and protection of assets, an item I think is top priority. In this, we raise questions like what happens if you become incapacitated, how to select a fiduciary, and how do you determine the provisions for distribution of funds. People in the military have the opportunity through duty station changes to own more property than maybe your average civilian. So making sure it is left appropriately can save your beneficiaries time and money. We also want to understand what a beneficiary designation means. And lastly, how do you want to gift cash? Estate plans look to minimize potential estate tax and proactively consider how things will be passed on and how property is titled. Let's review basic estate planning documents. Most military members are separated from their family at some point in their career, and many are deployed to dangerous locations. They're encouraged early to create a will and power of attorney, 2 of the first steps in estate planning, to protect themselves and their heirs if the worst should happen. A will becomes active only at death and is a matter of public record. It is a legal document under state law that appoints executor, directs distribution of the estate, and appoints guardianship over minor children. A will can create a testamentary trust, which we will discuss in more detail later. If a will becomes active only at death, what about if you are incapacitated? This is where a living will can direct your physicians of your medical desires. A power of attorney for health care is also important to accompany a living will. This enables a trusted person to make decisions about your medical care on your behalf should you be unable to do so yourself. A durable power of attorney is broader than a general power of attorney and different than a power of attorney for health care. A durable power of attorney will allow a trusted person to handle your financial affairs and, most importantly, be able to work with financial institutions. You also want to check with the individual financial institution to see if they have specific language or requirements that need to be listed in a durable power of attorney before having one drafted. Creating these documents is essential, as revisiting and updating them periodically. As life and circumstances change, it is important to keep them up to date. Now we're going to dive into trust. Simply put, a trust is created to hold assets while a person is living and allow a trusted fiduciary to use and distribute those assets upon death or incapacity. Most commonly, people think of a revocable trust, a cornerstone of estate planning. Created while the grantor is living, a revocable trust can be changed as needed. Typically, we see a revocable trust as part of a will, meaning that once a will becomes into effect, the items and assets listed in the will roll over to a trust. This can create privacy because trust documents typically are not public record. More importantly, it creates a seamless transition of management of assets. Now we ask, what happens if I die without an estate plan? If you do not have a will when you pass away, it is called state intestacy. The state will then decide how to distribute your assets based upon what relatives are living. Here's a sample of in-state flowchart. If you die without a will, your estate will go through a process called probate so that the court can determine how your assets are distributed. Probate takes time and money and is a matter of public record. If at the time of death you own property in another state, which it should be mentioned a lot of veterans do because of the frequency of duty changes, your assets must go through probate in the state the property is owned. This is called ancillary probate. Later in my presentation, I'll review how trust can protect your estate from the cost and red tape that can come along the probate process. Just as important as who you appoint to handle your estate is how you leave your assets. Titling of assets can be very important, such as individual titling, transferred by a will, joint tenants with rights of survivorship. This type of titling is seen a lot on property or investments owned by spouses together. It states that they have equal rights to the assets and also survivorship rights. Tenants in common, when two or more people have ownership in property, but the people can hold different percentages of the property, such as a 30-30-40 split, for example. Tenants by the entirety, a form of joint ownership of property when the owners of the property are married. Transfer on death, a transfer to a named beneficiary. Declaration of trust, found in a revocable living trust, typically from a person not married with adult children and a modest estate. Irrevocable trust cannot be changed and is controlled by the provisions of the trust only. So now we are going to talk about beneficiary designations. It is important to understand that some documents, like life insurance policies, are not controlled by a will or trust, but solely by a beneficiary designation. However, it should be coordinated with the rest of your estate plan. It is crucial to review beneficiary designations with life events, such as marriage, death, divorce, or deployment. Now, let's talk about gift and estate taxes. The annual gift exclusion is $15,000 for the year 2020, with the exception of medical or educational expenses paid directly to the service provider. Now, we should all strive to hit the estate tax exemption amount of $11,580,000 per individual, but most will not. But whether you have $11 million or $11,000, it's still important to ask and find out about estate inheritance tax to protect what you've worked hard to save. It's important to keep these thresholds in mind as you plan. As I have mentioned throughout the presentation, a trust can be an excellent way to protect your assets while you are alive and to safeguard your beneficiaries after your death. A trust will provide provisions for incapacity, control and protection of assets, avoid probate, and create privacy. I'd like to take a little time now to review a few types of trusts and its importance of choosing an appropriate fiduciary to manage it. One type of trust is a testamentary trust, which is irrevocable. A testamentary trust is often used with small children or special needs children. Like other trusts, it can reduce tax implications. It can also be checked on by the courts to ensure funds are being handled properly. Another type of trust, which I mentioned earlier in my presentation, is a revocable trust. In a revocable trust, assets can be added to and taken away during the lifetime of the grantor being the person who created the trust. At the grantor's discretion, it provides a seamless transition of managing assets if incapacitated or upon death. It can also help avoid ancillary probate on real estate held in other states. If you have a special needs child, then a special needs trust is imperative. Without a special needs trust, a child who inherits assets over a certain threshold may be disqualified for government benefits. Establishing a special needs trust can provide a secondary source of income for the care, needs, and quality of life of that child. Now, because trusts are complex, it is essential to select the right fiduciary to manage them. None of this will work the way you envision if you do not carefully select the fiduciary you trust. A fiduciary will act as an agent over your estate, financial or medical. They will be responsible for settling your estate, paying creditors, taxes, and distributing assets accordingly, as they are legally required to put the interests of the estate before their own. If minor children are involved in your estate plan, a guardian will be appointed to care for the children until they reach age of majority. A trustee is responsible for administering assets and distributing income. Some people prefer for a trustee and a guardian to be different, to create a check and balance as to how minor children's assets are being used. Consider appointing a corporate fiduciary. A corporate fiduciary, like AAFMAA Wealth Management and Trust, relieves relatives of the burden of trying to handle an estate while also trying to grieve the loss of a loved one. It can give you peace of mind knowing that a third-party person is going to ensure that everything is taken care of and that your wishes were carried out the way you wanted. When discussing estate planning for veterans, there are additional documents that are crucial to ensure all military benefits are applied for at the time of passing, including Survivor Benefit Plan, if retired military, your DD-214, Veterans Affairs Disability Compensation Award letters, and VA educational benefit letters for minors or spouses. So to wrap up this presentation, some main points I want you to take away are: select a trusted person to oversee your health and medical decisions. Do what is necessary to maintain control of your assets during your lifetime versus letting the state decide at death. Select fiduciaries to manage your estate and review them often, and make sure to review beneficiary designation documents often as well. So in conclusion, I hope this presentation has helped answer some military-specific questions about estate planning, but more importantly, I hope it's evoked a conversation and questions to think about. It's important to connect with someone who can help you build an estate plan that's specific to your needs. At AAFMAA Wealth Management and Trust, we know what it means to serve, which is why we make it our mission to serve you. Please reach out to me directly if you have any questions. And thank you, and have a great day.